SJC-11403, Commonwealth versus Eunice Field.
Ms. Caddick, good morning.
Good morning. May it please the court, Elizabeth Caddick for Eunice Field. Before the jury was even selected in this case, Eunice Field was denied her constitutional right to the effective assistance of counsel. She was denied her right to be tried while competent when it was revealed that during trial preparation, she could not effectively communicate with the defense attorney or understand the pretrial proceedings. Trial counsel had stated that there were times when this defendant, who had a longstanding history of bipolar disorder, would sometimes, without any prodding by him or answering any questions, would talk on in a euphoric and excited manner and not say anything substantive. And yet there were other meetings where she would not answer his questions or make eye contact. He said he did not generate much information from her. When it comes to the point of why he did not consult with an expert prior to trial, he said, well, she didn't really understand what was going on when I tried to discuss the point of an expert. He said, I thought because of her mental illness, she didn't understand the importance of it. And so he did not consult with an expert. Also, prior to jury selection in this case, the defendant was denied the effective assistance of counsel when counsel did not attempt to suppress her involuntary statements to the police. He allowed the jury to hear that Field had set up the meeting with the victim, brought a knife with her to the meeting, intending to kill the victim. She stabbed the victim, and as the victim was lying on the floor, still alive, Field said to her, you're feisty, and why don't you mind your own business?
So at the motion for new trial with Judge Healy found that the interview at Bridgewater would have been successful.
Yes.
A lot of the information, putting aside the forensic evidence, a lot of the information came out already at the first interview, and even information came out before that first interview even started. And it's I think Judge Healy's view was that there was a strategic reason to have the motion to suppress be heard, and also that trial counsel, who was very experienced, didn't want ultimately to have his client be interviewed by the Commonwealth expert. Why isn't that all reasonable?
Well, first of all, it may have been a trial strategy, but it was an unsound trial strategy. A defense attorney can't be immune from a finding of ineffective assistance of counsel by simply claiming he strategically failed to do something. It was unsound to ask the jury to come back with a second-degree murder verdict when he allowed them to hear that she premeditated the murder and that she almost taunted the victim while the victim was dying. And so, not surprisingly, the jury came back with guilty first-degree murder based on premeditation and extreme atrocity and cruelty. Second, the fact that trial counsel was experienced, you can presume that any appointed counsel in Massachusetts for first-degree murder cases is experienced and is presumed to be competent for the most part. That doesn't mean that in any particular trial they can be found incompetent.
Of course, absolutely.
Okay,
All right,
so
but he wasn't just experienced. He was experienced with the Commonwealth expert. He was experienced with criminal responsibility defenses, and as any good criminal defense attorney knows, the chances of getting a second-degree diminished capacity, where you lack a capacity to formulate the intent, is infinitely more likely than a not guilty by reason of criminal responsibility.
But there's no argument that he should have raised a not guilty by criminal responsibility based on lack of criminal responsibility. That's not been argued. That's not been argued post-conviction.
Why is that?
Well,
If you can say.
okay, well, I can't
I
really.
mean, a 33E review would require us to look at the initial motion that was filed that raised the lack of criminal responsibility, but was not argued on
Well,
appeal.
okay, what,
So help us understand why we should just overlook that.
when it was first filed, the motion for a new trial, first, counsel had filed a motion for funds, which the trial court had denied for expert funds. So then, Field had to file a motion for a new trial and then refile the motion for expert funds. So before Field even had an expert evaluate her, the motion for a new trial was filed, and it listed every possible defense that he did not look into. One of the things Field did argue is that even if defense counsel didn't think she could be found not guilty based on premeditation, it's possible she could have been found not guilty based on unable to conform her conduct to the requirements of law, because there was evidence in there that she talked about Lorraine was tormenting her mind. She had to do what she had to do. Only she knows what's going on. And so there was that possibility there. So the fact that I think to a certain extent the Commonwealth has created a straw man by going on and on about what would have happened had he tried to seek a not guilty based on, unable to premeditate premeditation. The other thing about the expert, the
But before you
main.
get there, to Justice Hines' question, can we
Okay.
just go back to that for a
Yes.
moment, please? Didn't Dr. Lang not testify at the motion for new trials that there was a lack of criminal responsibility?
He didn't. What he said,
So your own expert at the motion for new trial didn't give an opinion of, on criminal
not
responsibility?
guilty, exactly,
Okay.
exactly. What he did say is that because of her mental state at the time of the statement to police, and knowing that it was right after the murder, he said that he thought that she had some paranoid thinking and that she wasn't capable of acting in an extremely cruel and atrocious manner. But the main evidence against Field were those statements. And forget about what expert the Commonwealth may have sought to introduce 2 years after the period of time for filing motions to suppress. At the time, counsel should have been filing a motion to suppress. It had nothing to do with what might have been admitted at trial. If he had filed a motion to suppress, and we have the testimony from Dr. Land, that she was unfocused, she was possibly hearing auditory hallucinations. He couldn't say for sure, but she had a history of it, and there were times when she was not paying attention. Most of the time she was not paying attention. Her statements were illogical. She was talking to the ceiling. She was saying she could see into the future. She could see Tennessee. She's talking to her cats. And that she was irrational at the time she gave the statements, could not knowingly and voluntarily waive her Miranda rights, and her statements were involuntary, and certainly they could not have been used against her at trial. And so...
Well, let's stop on that for a minute, though, because if your expert had relied on those statements, then the Commonwealth could have gotten into those statements and on cross-examination under DYS versus the juvenile.
Well, first of all, in the motion to suppress, we're just talking about a hearing without a jury and a motion to suppress the statements. Even if the Commonwealth had its own witness at the motion to suppress and was able to bring in statements, that didn't affect what the jury would have heard. Also, Dr. Land didn't rely on her statements about the crime. He relied on her affect and her mental state at the time.
But Judge Healy said that the motion to suppress would not have been successful on those grounds.
Right, and it was argued on appeal that he abused his discretion in finding that the motion to suppress would not have been allowed because there are two reasons. One is, of course, this court has the DVD. Even the trial attorney thought she demonstrated mental illness, which is why he wanted the jury to see how inappropriate her behavior was. The problem was it also heard her admit to first-degree murder under both prongs. And so the fact that if the two statements were suppressed, and we also, in addition to just viewing it, the testimony of Dr. Land, which I certainly don't think was outlandish at all. Dr. Land
Wasn't required to credit Dr. Land's testimony.
Well, he didn't discredit, he didn't find that Dr. Land was, that either he didn't have the credentials or that he didn't say that he didn't believe Dr. Land or he didn't credit him. He just simply...
He obviously didn't.
Well, what he did, what the trial judge and the new trial motion judge did was focus on the behavior of the police, how they offered her water, they didn't raise their voice, they weren't rude to her, and he certainly abused his discretion when he found that her statements were appropriate. She rarely answered a question. Rarely. Almost all of her questions were what, huh, or no response at all. And so to say that she answered questions appropriately, and although sometimes there may have been a delay, for the most part she was, well, that's just an abuse of discretion, that finding of fact. That's just not right. So if you suppressed those statements, then what the jury would not have heard, of course, the premeditation and extreme atrocity and cruelty facts. What the jury would have been left with were some, perhaps, evidence. The evidence was...
Well, what about the statement to the EMTs, and when she drove up to the police station, nobody had said anything to her. She confessed to murder.
Well, that was involuntary. I mean, she was still, and also if what you had was before she was questioned, okay, she drives up to the police station right after the murder, covered in the victim's blood, gets out of the car, and they say, what is that on you? Blood, I just killed someone. If that's what the jury heard, that's not harmful. I mean, if that was allowed in, well, because the fact that Field killed Ms. Watsman was not, could not have been an issue. There was the victim's blood on her Field's blood in Watsman's apartment. We know that, so this is what the jury would have heard without the confession. It would have heard that Field had previously, 2 years before, been upset with Ms. Watsman because she perceived that the victim had prevented her from visiting a friend right before she died. That she had posted 2 months before, had sent a text message saying, I pray to God for the ability to forgive Lorraine, the victim. That she had made arrangements to meet with the victim the night before because she told her partner that she had. That she posted on Facebook, you're all going to be able to read my book entitled Tormented Minds by Lorraine Watsman. You're all in it. You'll read it tomorrow morning. There's some type of hint like that.
Lorraine Field.
Excuse me?
I'm sorry, you said Watchman.
Oh, Walkman.
But it was
the
Field
victim.
who wrote, yeah.
Oh, no, she said Tormented Minds, by Lorraine, by Eunice Field. Thank you,
right.
thank you. And that her neighbor had seen her backing out of the driveway that morning and she said, "I'm a little stressed, I'm about to get rid of some stress." So you have some indirect evidence that some, oh, I'm sorry, and then the note, perhaps the most incriminating was the note she left to her partner saying, Lorraine is going to get what she deserves for coming between us. I guess I must have just snapped.
Well, then you know what the prosecutor's going to argue.
Absolutely.
On this last point.
Right.
Going to argue.
Well, of course.
Even if. there
Well, that
was-
is not the quality of evidence that you have with her statements.
I know, but that's what, I want you to assume that you're right about
Okay.
that for the purpose of my question.
Okay.
So, what I imagine the prosecutor's going to say is even if you're right about the motions to suppress, so there was overwhelming evidence that perhaps could have been excluded because of extreme atrocity or cruelty, but the jury came back guilty of deliberate premeditation, and look at all the facts that you just marshaled in that regard.
I think that the first four, the text, the Facebook posting, those were not very direct. Even the "she'll get what she deserves" doesn't go to first-degree murder, of course, the fact that she was murdered. I also want to add one other incriminating thing of the list that would have been admitted, which was the knife. Without her statement, there was a steak knife, but there was nothing special about the steak knife. It had a brown wooden handle and serrated, and there were similar knives, the same type of knives, back in her apartment. But there was no testimony by, say, Renee Williams saying, "Oh yes, we always had 6 and now we only have 5." There was no and there was nothing about how it was special. But there's some indirect evidence that it could have been planned, but you didn't have that. And all he had to do was raise a reasonable doubt to first-degree murder. And we know the jury, even with her statements, even without an expert witness, the jury was asking questions. They were asking, what does it mean to have a bipolar episode? We know the evidence, and it certainly would have come in. She had a history of bipolar. She had medications that when she was on them made her not paranoid and made her see reason. When she was off her medication, she would be paranoid. She wouldn't listen to reason. Evidence she wasn't taking her medication, hadn't taken them for a while. And the jury asked, if someone is mentally ill and is on medication and they stop taking it, are they still responsible? And they asked to describe what a bipolar episode means. What does that mean? And then they asked during jury deliberations for the judge, who on his own thought there was enough to do a criminal responsibility instruction based on, so the jury asked, what does it mean to not be able to, conform your conduct to the requirements of law? So the jury, even with all that, was still focusing on a mental health defense. So would there have been a reasonable doubt raised? Yes, if he had suppressed those statements.
As to what? Reasonable doubt as to what?
As to whether it was first-degree murder.
As to premeditation?
Right. Right.
But in order for you to prevail on that, you have to basically knock out almost all of the statements that she made.
Yes. That's the argument, is that he should have filed a motion to suppress.
Suppress everything. Suppress
Yes.
what was said to the EMT, what was said when he walked to the police station, what was said when he
Right.
went to Bridgewater, everything.
Right, because they were involuntary. Because the arguments aren't just that her waiver of Miranda was unknowing and involuntary, but her statements were involuntary based on what her mental state was at the time. And even the
And when you say, so she was bipolar and but doesn't involuntariness require some element that they're unreliable? She was speaking in a very matter-of-fact voice of things that she did. I walked over, I stabbed her, I fully intended to do so, that was my plan. I know that there were hesitations and there were other things going on, but when you look at the content of what she says, it doesn't seem as if she was irrational when
But-
she was describing what she
But
did.
the test for whether statements are involuntary isn't whether someone tells a lie or isn't whether someone doesn't actually state what the other evidence could prove. And actually, we don't know that it happened exactly as she said. We do know that she had answered yes to multiple questions that turned out not to be true. And so when you look at what Dr. Land said her mental state was at the time, that she was that she had multiple significant mental illness symptoms at the time she gave her statement, that they should have been suppressed.
So if Dr. Land had testified, are you saying that the jury would have come back second-degree murder?
I'm saying if he had testified at a motion to suppress hearing, there are two sections to this argument. The most important one and the most significant is to suppress those statements.
So let's say that, so just have you run the table here, okay? So what do you say the motion to suppress had succeeded?
Yes.
Okay. And say Dr. Land had testified. Are you saying that the diminished capacity defense would have been more likely and it would have been a second-degree murder? What are you saying would be the result?
I'm saying if the statements have been suppressed, a diminished capacity at least would have been the result, a
Okay,
second
I
degree.
thought that's what you were saying.
Yes,
That you
yes.
think that as a result of the ineffective assistance, it would have been, could have been a second.
Right.
Okay, thank you.
Okay, thank you. Ms. Looney?
Good morning, Your Honors. Stacey Gauthier for the Commonwealth, Plymouth County. Trial counsel's strategic decisions to admit the defendants to videotaped interviews with the police and to proceed to trial without consulting with or retaining an expert, or mental health expert, were not manifestly unreasonable. And further, the trial judge, who was also the motion for a new trial judge, properly exercised his discretion in finding that the defendant lost no substantial ground of defense in the absence of filing a motion to suppress.
Your last argument, I understand. The first one, I'm not sure I do. Why would you not even consult with an expert under these circumstances?
Well, this is an experienced defense attorney in murders. He had handled he'd handled criminal responsibility in the past. And in his speaking with the defendant in the case, he found that he didn't think that she would present well to a doctor, an expert, for a mental health evaluation for a criminal responsibility exam.
What does that mean? She would not present well?
He stated that he didn't feel that she would have given the doctor the information that he needed to go forward. She didn't, I forget now what his exact words were.
Would that not itself be a reflection of a mental health issue? If she can't communicate effectively with
Well, I would
an
suggest...
expert retained by her attorney?
I would suggest not. This attorney wanted to put in the videotapes to show the jury. I would suggest it's one thing for an expert to get up and testify.
There's a different question of whether or not
Okay.
you're going to confer with an expert. Let's stick with this issue. Doesn't commit you to do anything. It just helps you to understand which defenses may be reasonable. But I don't understand why it is reasonable under these circumstances, given all the evidence of mental health issues, given the indisputable fact that she walked over to this woman's house with a knife and stabbed her, why you would not explore a mental health defense of some type with an expert.
Well, he said he knew that he could do that, but he wasn't sure what would be done with it. If, for example, if he used an expert, that the Commonwealth would then have an opportunity for our expert to examine her.
I didn't read Commonwealth versus Handwright before we came out today, but that's not necessarily true. If he's not going to rely on it and there's not going to be a criminal responsibility defense, and you're not going to rely on the expert, then you don't have to turn over the interview. I think the Chief's question is important to try and we need to get our arms around that question, which I'll put this way: what do you have to lose?
Well, he thought about it, he filed a motion, and then he said after consulting with her, he made the decision that he didn't think that he personally didn't think that she would qualify or she would meet the criteria for a criminal responsibility defense.
Isn't that the expert's domain?
Well, he's previously defended and used the criminal responsibility, raised the criminal responsibility defense in the past. I believe, I would suggest that he did make a reasoned choice not to hire an expert when he thought about how.
How is that? There was absolutely no risk involved in hiring an expert and talking to an expert. How can that be rational? Where there's no risk, there's none.
That's correct. Well, he chose not to. He felt in his professional opinion that he understood the criminal responsibility defense, that he testified that he had consulted with doctors in the past, that he had spoken to friends of hers, and he thought that he could raise that defense.
Well, that's kind of an after-the-fact rationalization of why he didn't do something that he could have done with no risk at all.
I mean, I can only tell you, I can't say, I can just tell you what he said, and that was that he thought that he could, that he didn't need it.
Your job is to tell us not just what he said, but the Commonwealth has to make us understand that that was okay, not just what he said.
If you don't, say you lose on that, say you lose on that part.
Yes.
Say we don't buy that that was reason, that was okay. Can you still, does this case still have legs?
If you find that he was ineffective for not at least consulting with an expert.
Right.
In other words, if he's manifestly unreasonable, doesn't there still have to be a showing here that something was lost?
That she would be she would lose an otherwise substantial available ground of defense. And in this case, she was still given the criminal responsibility, the criminal responsibility jury instruction, and she was also given the diminished capacity jury instruction. So I would suggest that even if you find that it was unreasonable that he didn't consult, at least with a mental health expert, it did not deprive her of an otherwise substantial available ground of defense, where she was still given the instructions on both.
But that's not the standard. I mean, if you get an instruction but you have no evidence to support it, that doesn't help you much. I mean, it seems to me that the strongest thing you have in your favor is that I don't see any expert, even in the motion for new trial, saying that she lacked criminal responsibility. So even if he had an expert, as far as we can tell from this record, there is nothing that would suggest that that expert would have offered the opinion.
That's correct.
He had criminal responsibility. So that leads us to whether or not there was a diminished capacity argument. And she says, well, it would have, if he had retained an expert, he would have challenged the voluntariness of all of those statements, and that would have knocked out most of the statements in which she admitted to what was apparently a premeditated killing. So why don't you address that issue?
Thank you, Your Honor. With regard to that, I would suggest that the statements were voluntary. First of all, the statements that she made when she initially arrived at the police station, she drove herself to the police station, so she voluntarily went to the police station, and then her car was blocking the parking lot entrance, so when the police had her get out of the car, they had to have her get out of the car to move it. They noticed that she was all covered in blood, and they said, oh, what happened? And then she first said, well, I just killed someone. And then she continued to answer their questions. And looking at the voluntariness of her statements, we look at the totality of the circumstances. And at least initially, when she was first at the police station, there was testimony that she did seem detached, but she was calm, she was coherent. At this point, she was answering their questions appropriately. I believe one of the fire chief had testified that she was lucid at that point. And then with regard, she voluntarily went with the Brockton police detectives to interview with them.
Well, do you agree that if all that the police had were the statements that she made when she drove up and got out of the car and with the bloody clothes. The Commonwealth would have had a lot of work to do to prove premeditation. Do you agree with that?
Well, it would have been harder for us. However, we would still have the note that she left.
Hard. Well, what evidence was there?
There was the note that she left with her partner that said, if something happens, my bipolar made me snap, and the victim is going to get what she deserves for coming in between us. They also had the neighbor who had testified that on the morning of the murder, she saw the defendant, and the defendant told her that she was going to go relieve some stress. There was also testimony, I believe it was from the partner, who testified that the defendant had called the victim the night before and made arrangements to go meet with her. Then there was there would have been the testimony from the ME that there was 9 stab wounds. I would suggest that that is evidence of deliberate premeditation. And then further, the motion judge found that the Brockton interview was voluntary, which I would suggest was the correct finding. And then
But the way he described it, I mean, he was describing a normal person in that interview, and an expert would have helped the judge to understand that this defendant was not really normal. I mean, you know, what he said was what you might say about the average garden variety person who's being questioned by the police, but this was clearly different.
Well, the judge, I mean, he would not be required to credit the testimony of an expert,
Yeah.
and he didn't in the motion, but he found that she was calm and cooperative. I mean, you look at the totality of the circumstances. She was calm and cooperative. They provided her with a glass of water. They read her Miranda warnings to her. They told her that they would stop at any time. She said yes when asked if she understood her rights. And then they stated, having those rights in mind, do you wish to waive them and speak with us? And she said yes. They then offered to go over any other warnings. They said they didn't mind. She told them that she could read. She made no indication that she didn't understand any of her warnings, and she signed the form. So I would suggest that also, in the totality of the circumstances, that also would go to the voluntariness of the statements.
Can we separate the strategic issue of not filing a motion to suppress from the manifest unreasonableness of not at least consulting with an expert?
Well, I don't believe that there's a requirement to consult. I believe under Commonwealth versus Lang, it's that he has to make a reasoned choice whether further investigation is warranted. And I would suggest he did think about it. I mean, he had prior experience with criminal responsibility. He had prior experience with the Commonwealth's expert. He had prior experience dealing with experts. He spoke to the defendant. He spoke to her friends. And in his professional opinion, he didn't feel that further investigation was warranted. I would suggest he considered it, and I would suggest it was a reasoned choice.
Okay, so your short answer then would be, no, you can separate the strategic decision of not filing a motion to suppress from just deciding not to check with an expert, which is sort of hard to reconcile.
Yes, I mean, he thought about it, he considered it, he filed the motion for funds, and then he didn't. I would suggest that he did make a reasoned choice.
Well, what about Rosario? Was he obligated under Rosario to look at this and not make his own judgments about the defendant's mental state?
I would suggest that under Lang,
No, Rosario.
I'm not familiar with Rosario, but I'd be certainly happy to look into it, and I would do a 16L for you, Your Honor.
Okay.
Okay, I'm sorry.
I probably should know this, but did Dr. Land, in the motion for new trial, offer the opinion that her statements were involuntary, that all of her statements were involuntary?
Dr. Land testified that she could not voluntarily make statements. That was his testimony, that they weren't voluntary. He did not testify that she was not criminally responsible, and he did not testify that she could not deliberately premeditate. He did testify that she couldn't act in an extremely or atrocious manner.
And I read Judge Healy's quite lengthy
Yes.
findings of fact, where did he address his view that he did not credit Dr. Land's testimony with regard to her voluntariness?
Well, he didn't specifically say that he did not credit Dr. Land's testimony. However, I would suggest that by finding that the statements she made at the Brockton interview, as well as the first half of the Bridgewater interview, I would suggest that you can infer that he didn't credit his testimony, that her statements were completely involuntary.
So is this referring to what's Appendix 47 on page 19? I'm trying to find where his, I remember him discussing competency to stand trial, suppression of the videos, but I don't remember him addressing the testimony of the expert in discussing it. I know that he discussed the issue of whether she invoked her right to silence in the Bridgewater interview.
I know that he stated that the statements the defendant made in the last third of the last half of the Bridgewater interview added evidence to the extreme atrocity.
Right, but that goes to her invocation of silence. That I understand, and I understand his finding that that would only have affected the jury's verdict on the theory of extreme atrocity or cruelty, but it would not affect their finding on the theory of deliberate premeditation. But I don't, again, I mean, I read it last night. I just don't recall seeing anything in which he addressed the testimony of Dr. Land with regard to the issue of voluntariness.
Your Honor, on page 48 of the appendix, and it's page 20 of the judge's decision, but it's page 48 of the appendix, the last sentence of the second paragraph, he stated that the defendant has not shown that her statements in the Brockton interview about the killing of Ms. Waxman would have been suppressed. He said that, and then if you go to the beginning of that paragraph, he stated that when the defendant answered the detective's questions about the killing, her answers were coherent and rational, despite some odd slowness and pauses in manner of her speech. She never said she was unwilling to answer any more questions. The defendant has not shown a lack of understanding or a lack of voluntariness in her Miranda waiver and her statements in Brockton.
So what do we do with, I mean, I guess
I would suggest that
sometimes I'm right, which is that appears that he did not address Dr. Land's testimony, at least directly.
not directly, Your Honor, but I would suggest that by finding that her statements were voluntary, which was opposite of what Dr. Land testified, I would suggest that shows he did not credit Dr. Land's testimony, at least with regard to that, to the Brockton interview, with regard to that.
And what, I mean, he wrote a single-space, 22-page set of findings, but it seems as if this case rests ultimately on that issue. I mean, that is right now, as far as I can tell, because I don't know that the defendant prevails unless the defendant can persuade us that if they had retained an expert such as Dr. Land, it would have affected the finding of voluntariness. And what do we do with the fact that the judge did not address Dr. Land's testimony, directly at least?
Well, I think we have to look at what he did find, and what he did find was that her statements in the Brockton interview were voluntary, and that her statements at the beginning of the Bridgewater interview were also voluntary. He was the one who was at the hearing and saw the doctor testify, so I would suggest that it was up to him to determine the credibility of the witness. I think we can say that he didn't credit him about voluntariness by his finding. And
Go ahead.
sorry. Again, there was still ample evidence, I would suggest, with regard to deliberate premeditation. Again, we have the note, we have the neighbor who said she was going to relieve some stress on the morning of the incident. We have the partner who testified that the defendant had made arrangements to meet with the victim the next day. We have the 9 stab wounds. So I would suggest that would, sorry.
I think I just would like to go back to the question I asked you before. Just assume, I know that you disagree, but assume it was manifestly unreasonable not to at least consult with an expert.
Yes.
Can that decision, that if we find that's manifestly unreasonable, be separated from the strategic decision not to move to suppress the evidence because the defense counsel believed that it was evidence that would be helpful for the jury to see, considering the rest of the evidentiary landscape? Do you understand my question?
I'm sorry, could you repeat it?
Sure. Can we say that we think that it's manifestly unreasonable, not at least checked in with an expert?
Okay.
Can we analyze whether the decision not to file a motion to suppress, because defense counsel thought it would be helpful to the case and diminished capacity for the jury to see the entire interview, can that determination by us, whether it was manifestly unreasonable not to file the motion to suppress, be separated from the decision not to seek an expert?
Well, I mean, it has to deprive her of an otherwise, it could be unreasonable, but it has to deprive her of an otherwise substantial ground of defense, which I would suggest that this did not. She was still found guilty of deliberate premeditation, and there was ample evidence, I would suggest, of her deliberate premeditation, even if the statements had been suppressed. So I would suggest that it can be separated because it didn't make her lose an otherwise substantial ground of defense. Again, at the end of the day, she got the criminal responsibility instruction, and she got the diminished capacity instruction. So what defense was she being deprived of? She ended up with the instructions.
Okay, I think you mistake the term denied a defense means more simply than that the jury was instructed. It means that you were denied a reasonable opportunity to persuade the jury as to that defense. But I think your time is up, so thank you.
Thank you.